Court is resumed. Please be seated.
Before the lunch break, we were examining spectrum and why spectrum should be an included revenue source. And the next kind of argument the next argument that's advanced by Canada's experts is Bodway and Smart, Minson and Ryden say that spectrum is to be equated with things like pipelines and airplanes traversing land. And they suppose that only resources like trees or rocks or water counts, things that are part of the land. Respectfully, treaty promises about productions from the treaty territory, and the judgment only requires that the revenue source be closely related to the use or licensing of lands or waters. So I don't think that it's that important whether it's the use of land or a thing on land that matters. It's whether or not through control over the land, through its administration and control, the Crown is able to extract revenues from something that is closely related to the licensing of land. Now, at paragraph 154 of their main argument, Canada argues that spectrum is not owned, and at paragraph 155 identifies spectrum as something borrowed. Now, the analogy of borrowed is perhaps apt. If something is borrowed and controlled by another and licensed by that person, it's licensed and a shareable resource. That's a shareable revenue stream, excuse me. As for the argument that spectrum waves are not owned by anyone, one can actually say the same thing about water. Spectrum revenues are, we say, actually fairly similar to toll charges that are closely related to the use or licensing of land. The Crown, as owner of the Crown lands, does have the right to charge tolls to people traversing across Crown land. It does have the right to charge a toll for planes in its airspace. And the court might remember that there was a discussion in the evidence with Professor Mintz about that very issue of charging planes for when they go through Canadian airspace. That's at transcript page 2937 to 2939. And the Crown does have the right to charge a pipeline or a railway for the use of traversing land. And I believe there's even one highway that's a toll charge in Ontario. Doesn't happen to be in Robinson Superior Treaty Territory.
Could be coming soon.
It could be coming soon, exactly. There's only one way to get to Manitoba eventually, if you want to go through Canada. And perhaps that's a good toll charge. At paragraph 160, Canada says that spectrum waves are unlike minerals, lumber, or water, which Canada argues are linked to land. And I want to return to the point that water is not linked to any land at all. In fact, water is not the subject of ownership at common law. The Crown may have appropriated legislatively all water power within its geographic bounds, and I say save for reserves. That's a special matter for another day. But the water itself at common law is actually not owned by anybody. So I think it's fair to say that spectrum waves, like waves of water in a stream passing through a turbine, provide economic value due to the water traveling through the turbine. I suppose you could say there's also economic value in the potability of water, but in terms of its water power. Similarly, spectrum are electromagnetic waves passing across a geographic region, which also require a tower and a cell phone for it to have any value. The physical connection to the land, like water, is actually irrelevant. Next, Canada.
Sorry.
Yes.
The very last line, the physical connection to the land is
Irrelevant.
irrelevant.
Yes.
And that's because you say
It's productions from the treaty territory.
coming from the territory,
Yes.
and but for the territory, there would be no, but for the administration and control of the territory,
That's right.
there would be no licensing fees.
The value of the spectrum comes from the geographic incident, that is the fact of the control over a geographic region.
Right.
And the spectrum waves, which exist in nature, like water, traverse through the geographic territory. And because the Crown is lucky enough to have appropriated to itself the value of spectrum by preventing other people from jamming. So the Crown says it belongs to the Crown. If they didn't pass that legislation, anyone could jam the signals, and you would have Rogers and Bell going to many individuals saying, can I pay you for the privilege of not jamming my signal? At paragraph 156 of their main argument, Canada calls into aid two Supreme Court of Canada cases, which they say stands for the proposition that hydropoles and airspace they occupy are not land over which someone has full ownership rights. And I have to confess, maybe I haven't given their argument justice, but or I haven't paraphrased it correctly, because I don't think the two cases, the Soyuz case and the Opitshelsat case from 1997, stand for the proposition that supports that spectrum is not a proper revenue stream. The 2001 Soyuz case was a case where a band wanted to tax the owners of a canal running through their reserve. The canal had been granted and authorized by the Crown, and the majority held that the band still had the right to tax the use of land because the land was still part of the reserve, even though there was a canal there. Now, Canada relies on the dissenting reasons of Justice Gonthier, who was of the opinion that the lands in question had ceased to be part of the reserve and hence could not be taxed any longer under the Indian Act. In the course of his opinion, Justice Gonthier, at paragraph 188, likened a canal to a highway or a railway and felt that highways through reserves should be treated differently than a utility line or a hydro pole that for the most part took up only airspace. I confess this excerpt I believe to be unhelpful in determining whether spectrum is a Crown resource related revenue. There seems to be a disconnect from an obiter comment that hydro poles take up airspace to jumping to the conclusion that spectrum is not a Crown related revenue. As for any question on that? No. As for the 1997 OPETCHESAHT, I believe it's spelled, case, that one concerned whether Section 28(2) of the Indian Act, which allows the Crown to grant permits when it is granted for so long as hydro needs it, was a valid permit under the Indian Act, which requires there to be some period of grant. The Supreme Court of Canada said it was. Now, Canada calls into aid paragraph 50 of that judgment. And in that case, the court did not distinguish between easements or rights of way and interest in land. They said that the right of way was a limited interest in land. And we observe that the fact that these hydro pools took up mostly airspace was actually irrelevant. The disposition in that 1997 case was simply that no surrender was required by the First Nation in order for the Section 28.2 permit to be valid. So we don't see that case as being particularly helpful in answering the question, are these revenues from spectrum something that is a production from the treaty territory? Finally, at paragraph 157, Canada argues that since technology is needed to access spectrum's value, it is unlike water or minerals to which technology is not inherently required. On this one, I think I am going to be bold enough to say that I think Canada is definitely wrong. Water in a stream has no water power without the invention of the water wheel, and all the nickel in Sudbury would be one massive subterranean paperweight with no value to the owner without the technology to extract and process it. So technology has nothing to do with whether or not a resource has value. So for all the above reasons, and especially that included in our, and I didn't cover all of the points in our argument, but we say spectrum is a relevant revenue source. And as we go into the future, I know it's not that big of an issue for the past because it hasn't existed to be, it hasn't been capturable until recently in modern times. But as we go into the future, it and other forms of transmission across territory will become an important source of government revenue. And I can only think of one that, hearkening back to my days of reading, well, maybe it was science fiction, maybe it was science, but this fellow by the name of Tesla had developed some way to transmit electricity through the waves, through the airways without needing towers. You could just transmit it without wires. You just transmit it through the land. He actually did an experiment back in, maybe it was 1903 or so, where he lit up a bunch of lights some distance away from his Tesla tower. Now that technology is being refined, I understand. And so I expect in the future, things going through the air, whether it's wind turning turbines, whether it's electromagnetic waves from a Tesla coil, or whether it's spectrum, are all important aspects of revenues that come or related to licensing of lands or waters within the treaty territory. And we want to ensure as part of the judgment in this case that and we've asked for it, and we'll get to it at the end, that the judgment be refined to reflect that the use of air is an important aspect of what needs to be shared.
And you say spectrum is a use of air?
No, I say spectrum is the use of, it goes through the air. Waves through the air, sunlight waves through the air, which are captured, wind that goes through the air that is captured, and electricity, electromagnetic waves that go through the air. And I can't explain how the Tesla coil works, but I do know that it was demonstrated in the early, somewhere between 1900 and 1910, and I have no doubt that science will figure out a way to do it efficiently in the future.
Can I just go back to this,
Yeah.
this point then? You talk about refinement of the judgment that believe what you're saying is currently refers to productions arising from use of the land and water.
Right.
And you say you'll ask for it to be refined to include uses of the air, or?
I think I actually, if I can find it in my, it's in my appendix A, I hope.
Oh, right.
At paragraph number 6, I suggest, which we could say, and that right now it says relevant revenues to be considered are Crown resource-based revenues arising directly or in a closely related way to the use, sale, or licensing of land, and then in brackets, which could include the waters, and then I think we should add in, or airspace in a treaty territory. And then continuing on, including minerals and lumbering revenues, and I would add in, and spectrum revenues, to be clear that spectrum could be included. And of course, the court might remember that the order actually says with these terms to be general terms to be dealt with further in stage 3. So it wasn't an absolute fixed listing. And now that we've seen what kind of revenues there actually are that are properly and fairly connected to the lands and waters, we should be expressly adding in use of the air and spectrum. If there's no questions on spectrum or transportation, I would turn to relative wealth and means. Now, the Court of Appeal identified that a consideration of the relative wealth and means of each community is a relevant consideration. We discussed this in our main argument at pages 34 to 36 and at paragraphs 162 to 171. Stiglitz and Hutchings discuss it in their opening report at part 8 of Exhibit 3, pages 85 to 90. It's also in Hutchings' opening report, Exhibit 8, pages 111 to 170. And also in part 4.D as in David of the Stiglitz and Hutchings Joint Reply Report, Exhibit 4, at page 35, paragraph 72 to 77. Now, I wonder if the court could turn to tab 15 of the compendium. Tab 15 of the compendium contains 2 documents. The first is the aggregate income gap, that analysis that was done by Stiglitz and Hutchings under 2 scenarios. And I just wanted to remind the court of where the numbers drive you to. So anywhere from at 60-40, anywhere from 153 to 193. The second excerpt or in the compendium is on page 90 of the compendium, is page 114 of David Hutchings' report. And I thought this particular graph or figure 13 was a good example explaining.
Can you just remind me, high growth and low growth, were those populations?
Yes. The high growth and low growth was the population scenarios that Dr. Bignami suggested, saying, I have the, basically she said, I have the populations now, and depending on what growth rate I assume, I can tell you what the population was likely in 1850. Uh, Dr. Dribbin, evidence supported closer to the low growth scenario, which would make sense because he was saying, look, there wasn't a huge change in population for quite some time. The population was pretty steady. So that would coincide with the low growth scenario, which, and I think the court appreciates with the low growth scenario, you end up with a higher income gap. That's just the way the math works. So I was looking at figure 13. Figure 13, I thought, was illustrative of how the prospects and income of the RST Anishinaabe compared with the total income per capita overall of people in Ontario. So if you see the Anishinaabe line down at the bottom, it seems to be disconnected to the shaded area, which is the net crown revenues that the wealth of the land, if you will. You see the bluish gray shaded area, and you'll see that the green, it's green to me, the top line. The green line kind of tracks the wealth from the treaty territory, and that's what you might expect. You might expect that as the treaty territory spits out wealth, well, the people in the treaty territory should benefit. And what we have is we have the non-Aboriginal people following along the growth in resource revenues, but we have the Anishinaabe lagging far and far behind with a large income gap. The main issues in dispute, as I understand it, in respect of the wealth disparity issue, seem to be one, should the disparity simply be confined to the existing population, as Beaudoin and Smart did? Two, is it appropriate to look at the award on a per capita payment? Three, in calculating the income gap, should the mean or the median income be used? And four, should housing be included or excluded from a consideration of relative wealth? Now, in respect of each of those four positions, we ask the court to adopt Stiglitz and Hutchings' approach. We say that their opinions on this was not challenged, and it makes, and in respect of the first point, we say, one, it makes no common sense to confine deprivations for a claim going back to 1850 so as to confine the loss to a cohort of band members currently alive. That would result in a reward to the Crown for the delay in honorable implementation. That can't be right. Now, Mr. Beaudoin, Professors Beaudoin and Smart had the idea, and I'm not sure why they only used current populations, but they did. And of course, if you only use current populations and you then treat the collective losses for 173 years as a windfall to one generation on a per capita basis, you get these astronomical numbers, which are, I don't know, almost by their very, expressed as a per capita basis, it looks like all of a sudden everyone in the Robinson Superior Treaty Territory belonging to Robinson Superior Band is going to become a millionaire, and that's a bad thing, and that's unfair, and that's not the way things should work. The second point is really that it makes no sense to treat the collective losses of the Anishinaabe experienced over 170 years, 3, 4, 5 years, as though the current cohort are going to receive a per capita payment of millions of dollars each, or whatever the math turns out to be. Third point, Mr. Hutchings' defense of the use of mean as opposed to median was not successfully challenged, and Professor Bodway at cross-examination, page 7773, says whether or not to use mean or median is a difference of opinion. And I'm going to ask the court to prefer the opinion of Stiglitz on this point. I would observe that whether one uses mean or median doesn't really change the result so dramatically as to render the deprivation calculation as meaningless. It's still going to be large. Fourth point, Professor Bodway all but conceded that including housing wealth was appropriate. That's cross-examination of Bodway, page 7758, lines 16 to 20, and 7774, line 22 to 25, to 7775, lines 1 to 2. Finally, Professor Bodway all but endorsed the income gap approach as a fair and reasonable approach to wealth deprivation. He said, the output gap is certainly a defensible way for analyzing, as I'm not sure if the word is analyzing or looking at, as Professor Stiglitz and Hutchings say, well-being. And you'll find that at page 7766, lines 6 to 9. I was measuring. Okay. I couldn't read my own handwriting. The output gap is certainly a defensible way for measuring, as Professor Stiglitz and Mr. Hutchings says, well-being.
Is output income?
The output gap is the income gap approach. Canada, in its reply at paragraph 13, suggests that the plaintiffs are somehow seeking to utilize the result of the deprivation analysis twice. We are not. We make this clear at paragraph 252 to 254. It does indeed, a relative deprivation analysis is a litmus test to sharing and is a factor in considering and identifying the loss of opportunity to engage in a process, and is not intended to or sought to be captured twice. It's not even actually, we're not actually really trying to capture it once. It's a reflection, and it's an idea of saying, of the 126 billion available that of resource rents to be captured, if you captured all of that, you still would not satisfy the deprivations. You wouldn't deal with the historic deprivations even if you gave everything by all the resource rents actually captured. Even if you gave all of that to the Anishinaabe as their share that is appropriate in a judgment, that would still not respond fully to the deprivations that have been suffered. It would not address the actual loss. So I think that the large numbers of deprivation, we're not trying to capture those numbers, but they're a good litmus test if the judge is looking for, if the court is looking for what is fair and just under all the circumstances. And if it's important, as the Court of Appeal says it is, to look at the relative deprivations of the parties over time. Well, if you look at that, then even an award of 126 billion isn't enough. It doesn't satisfy the deprivations, doesn't address the loss. Finally, one point in respect of deprivations, the Court of Appeal observed at paragraph 322, they didn't observe that the Anishinaabe wouldn't have wanted to have wealth, they wouldn't have wanted to have capital, they wouldn't have wanted to have the ability to provide for their own people. What the Court of Appeal observed at paragraph 322 is that the Anishinaabe would not have wished to enjoy great personal wealth while their fellow Canadians suffered deprivation. Now, I think it's important in this case that the Crown, neither Crown, chose to lead any evidence that the payments of the amounts sought when they were due over the years in the past, since 1850, had they been paid, would have resulted in any deprivation of the fellow Canadians, The evidence is just not there, and there is no presumption that the court should accept that there is going to be hardship, or sorry, not is going to be, was any hardship or would have been any hardship in 1922 if a just amount had been paid in 1922. There's no evidence of hardship to fellow Canadians if the proper amount of payment had been made in 1963. And as for the question, well, what about today? If we have to pay a lot of money today, will there be hardship in us paying today? That's not a fair question for the court to consider. I don't think it's fair for the plaintiffs to say, we didn't honor our obligations for 173 years, and now, court, you must go easy on us because it's so much money. I don't think that's a fair factor for the court to consider, and I believe I took the court to some law on the first day to that effect. And unless there's any questions on relative wealth and needs, that's all I have to say about that.
Thank you.
Next, we turn to the appropriate bring forward rates. Part 6 of our main argument, pages 117 to 127, and Part E of our reply, fashioning a just award, address these issues. To a large extent, when I dealt with the issues of benefit of hindsight and the availability of deterrence, I addressed many of these issues already, and I'm not going to repeat them. I will observe that Canada basically agrees with our position that equitable-like principles should apply, and Canada will probably speak to the reasons why equitable-like principles apply. There was this disagreement about the benefit of hindsight and the availability of deterrence. What I wanted to focus in on today is a couple of matters that I don't believe I covered in my material directly. The first is Boatway and Smart, you might recall, had this idea that when a person invests in equities, the real benefit they get is not the rate of return on the equities, let's say it's 11%, but they only really benefit from the risk-free rate of 5%, say, using their bond rate. And the difference, say it's 6%, compensates them really for worries and transaction costs, and they don't really benefit from that extra interest that they get. That was a very mystifying part of their testimony. And I'm going to chalk that up to an example where economic theory in the ivory tower ends up making no sense in the common law world, in the real world. It didn't make sense to me to say that people who invest in equities actually don't really benefit from that. That made no sense to me. Second point, Canada at paragraph 189 makes the point that investing outside the band trust account rates was not allowed between 1860 and 1951, but doesn't really mention, and of course mentions somewhere else in their argument, this is in respect of money that had to be invested in the band trust accounts. So it's not really an argument at all for the band trust account rates. It's an argument, it's almost a circular argument to say, if you were compelled to invest in the band trust account rates, then the band trust account rates are all you could get. Okay, we can accept that, but we didn't have to invest in the band trust account rates, and neither Canada or Ontario argue that the annuity monies in this case are monies that had to or even could go into the band trust accounts. Now, the argument that Canada cannot be compelled to invest in instruments other than the band trust account when investing Indian monies is predicated on a band alleging that the Crown had a fiduciary duty to invest the money for them. We, in this case, do not have an allegation that the Crown we expected the Crown to invest the money for us. We do not have any fiduciary duty here where the Crown would be investing the money for us. And even if we did have a fiduciary duty, we do not allege that there was a duty to invest those funds in the band trust account. The evidence was from 1873, the Anishinaabe wanted the annuities paid to them directly. And the evidence is, we already know that when vast amounts of money were paid to a band, they eventually sought a trustee and invested money in England. That's the Six Nations. I appreciate only limited evidence, but that's what it is. Ontario explains at paragraph 505 of their main argument and following that the Supreme Court of Canada in Bank of America recognized three factors embedded within interest rates in a bring forward calculation. And I think they correctly identified three elements. The three elements are an opportunity cost, a risk, and an inflation factor. The opportunity cost, Ontario argues, and I think it's correct, what could I have done with the money? That's the lost opportunity. That is to be distinguished from risk, which is the uncertainty inherent in delayed possession of money, which may or may never be paid. So there's an element to be stacked onto opportunity cost for that. And the third element is inflation, which reflects the fluctuation in price levels over time. Now, here's the interesting part. At paragraph 510, of their argument, sorry. This is their main argument, sorry. Pardon? Page 139, thank you, Ms. Lewis.
This is Ontario.
This is Ontario's, yes. Ontario identifies that the long-term bond rate isolates the opportunity cost in their model at 5.1%. Now, it follows that if 5.1% is the opportunity cost, what is the proper rate of return or the proper rate when you add in the risk and inflation? Well, what is the inflation rate? In Ontario's argument, they say that Booth and Kersner said in their report that the interest rate is for inflation averages 2.92%, and they cite Exhibit 40 from Kersner's demonstrative page 32 as the source of that data, that it's 2.92%.
I just,
Yeah.
go ahead.
Okay, so remember, let's start with the opportunity cost is 5.1%. And now we're looking to figure out what the risk and inflation add-ons should be. And Ontario says, well, the rate of inflation is estimated at 2.92%. And they say that their source of information for that is Kersner's slide deck, Exhibit 40, page 32. It doesn't say anything about interest rates at all. So they've got the wrong citation, but I believe I've got the right one. I can help them. Unfortunately, it's not 2.92. It's actually 3.57. And if we could bring up Canada's exhibit, and Canada was kind enough to summarize this, well, not for me, but for the court. I'm not sure if it was in opening. No, I guess it would have been midway through the court case. Canada brought forward, you might remember this document with all the Exhibit 42 with all the various interest rates on it. And this was discussed at transcript page 3492. And there was a discussion about the proper average interest rate for over the whole period on inflation. And it's not 2.92, it's 3.57.
The average interest rate
Of inflation.
of inflation.
Yeah, so if you wanted to just account for inflation on average, you would need 3.57%, not 2.92. So Ontario's got the number wrong, is my point. I don't know where they got this 2.92 from. It maybe it was from an earlier version of a report somewhere, maybe, I don't know. But I do know that what Canada put in evidence was a corrected 3.57% rate. My point is, that if it's true that 5.1% is the opportunity cost, and if you add inflation to that of 3.57, you get an appropriate bring forward rate, not of 5%, but you get an appropriate rate of 8.67%, a nominal rate of return higher than the average rate of return that Stiglitz and Hutchings are advocating for, and that the plaintiffs say is fair and reasonable. There's another way to kind of look at how Ontario has crunched the numbers here. And it's to ask yourself, well, if it's true that 5.01% or the bond rate is a fair rate to use, and if it's true, as Canada's expert says, that inflation averages at 3.97%, then the real rate of 3.57, excuse me. And if inflation averages 3.57%, then the real rate of return that Ontario believes is just and appropriate, and that Canada believes is just and appropriate, is around a real rate of return of 5.01 minus 3.57, which is about 1.44%. Now, a 1.44% real rate of return is really a far cry distant from the real rate of return of 5 or 6% that people in 1850 expected to receive when inflation was not a repeated and persistent problem. And a 1.44% real rate of return is, with respect, removed from what I think the court can know about common sense and the human condition. The court is really left with the question, is it reasonable or probable that with millions of dollars coming in annually to the First Nations coffers from sometime after 1850, it didn't immediately, there wasn't big monies really early on, but by the 1860s, things get rolling. To the present, millions of dollars come in. Is it reasonable that the person responsible for overseeing that money would content themselves with a 1.44% rate of return when they didn't need all of that money and they were investing for the long term? When they knew that equity rates of return, or their expert who they hired would know that equity rates of return were 9% or more? It just defies the human condition to believe that the Anishinaabe would be content with 1.44%. Now, we say that the plaintiffs are relieved of the responsibility of actually having to prove that they wouldn't have been content with 1.44%. Although we say that on the evidence, the court can find that we wouldn't have been happy with 1.44% real rate of return. But we say they're relieved because of the presumption of highest and best use based on the facts of the case, whether equity or common law applies. And I said, even without the presumptions, the plaintiffs, the court should remember, are only required to lead evidence that is within their possession, power, or control. And what we have, until there was significant monies to invest, there just is no evidence of what the Anishinaabe would have done with vast amounts of money. The one thing that we do know is that as soon as bands like Michipicoten and Fort William do get large sums of money, they invest it for 7 generations to help them in the long term for the future. And it's not an unreasonable inference that had that money come in earlier, they would have done the same thing. I've already addressed the point that the 5% or 5.01% bond rate is the rate at which the Crown would borrow and doesn't reflect the loss. I remind the court that both Ontario and Canada claimed that the annuity monies could not have gone into the band trust accounts, wouldn't have gone into the band trust accounts. If that the money is collective and would have been paid to the chiefs and their tribes who are under a fiduciary duty to invest that money for their First Nations. And if the court asks the critical question, what would those chiefs have done, chiefs and councils have done upon receiving monies that they didn't truly understand just how to invest it? what they would have done, they would have had their eyes on 7 generations. They would have reached out to other people to help them. And the investments would have flowed into the best possible choice that a fiduciary would make. Not the fiduciary Canada, but the fiduciary chief and counsel. And whether they would invest in the market or whether they would invest in their people, the rate of return they would get would be, if they invested in their people, the rate of return they would get would be higher than the market rates. Unless there's any questions on interest rates and bring forward, that's my argument on interest rates.
Thank you.
The next question is the Anishinaabe share. We talk about the Anishinaabe share in, or Stiglitz and Hutchings talk about it in their opening report at paragraph 121 and following, and in their reply, paragraph 91 to 95. We say that the share should be 84% for the Anishinaabe and 16% for the Crown. Now, why did we say that? Why did Stiglitz and Hutchings say that? It has to do with some measure of rewarding each party to the joint venture in proportion to the risk that they're taking. Part of the complaint of Bodway and Smart and by the Crowns is that, well, the $10 isn't a buy outright amount. So it's not a proper comparator, but it is. And think of it this way. I want to go back to the, I guess, stage one. The court should remember that the $10 pre-Robinson annuity amounts was untethered to the value of the land.
Yes, I can tell you that I do have problems with this 8416, so don't hesitate to start at the beginning.
Yeah.
If I can follow the dots.
Okay. So we start off then with a situation where prior to 1850, the Crown could say, or was going around to First Nations, and from the Crown's perspective, not the Robinson Superior perspective, but the Crown's perspective was that if they paid $10 per capita to a fixed population, so a fixed amount, they would secure the benefit to themselves of the whole of the treaty territory. So the cost from the Crown's perspective of a full buyout, not from the Anishinaabe in 1850, but from the Crown's perspective in 1850 of a one-time purchase, if you will, is $10 times the population in existence at the date of treaty. And the court might recall Robinson's instructions from Trial Exhibit Phase 1, April 16th, 1850, instructions to Robinson, Exhibit 1A hyphen 0767.2. That was the instructions where Robinson was told, you should assume you have 25,000 pounds, you should assume that there's going to be 1,500 pounds down, and you should assume that there's 600 people, and you should assume that there should be if it goes below the population, you should deduct $10 per person. And when you do the math at $600, this came up in phase one, I believe, or stage one. When you do the math at 600 people, it's exactly $10 per person. So in the mind of the provincial executive, as affirmed by the imperial government, the idea was, go out, Mr. Robinson, and buy this land for a one-time purchase of $10 times 600 people. Now, Robinson, why they gave him those instructions when everybody knew the population was more than 600, but that's the instructions they gave him. You have a question?
Well, I always wanted to know the answer to that question.
Why did they say that?
Why did they say 600 when they had the population figures from Fidel and Anderson?
I have no idea. That's a mystery.
Is it, this is the budget we have. This is the budget we have. This is how we used to pay. So we'll all just pretend that we're paying the same rate.
Well, maybe, I wonder, at this point, we're almost speculating, though. That's the problem. I don't want to speculate. I mean, that's a good speculation. I mean, I might share it, but I don't have any evidence that makes sense to back up that speculation. And we have to be I think I have to be very careful in not overselling, turning my views about what should have happened or could have happened into evidence. The evidence is that this is what, can you put it back up on the board, please? The provincial executive did tell Robinson, these were his instructions, and the claimants should not be less than 600. Somehow, when you use 600, you come up exactly with £2.10 per head is actually $10 per head. We all know that. And so the question is, how then, why then would the provincial executive do that? And what comes in my mind, what makes sense, is maybe they thought the $10 per capita was the way to go. But we won't know, unless new documents are unearthed sometime in the future, we won't actually ever know. But what it does tell us is consistent with the Crown's conduct for every other treaty from 1818 to 1850.
What they did or what they said?
No, what they did between 1818 and 18.
What they did in 1850 is consistent with what they had done.
What they said in 1850 is consistent with what they did from 1818 to 1850. Right? $10 per capita for an existing population. But remember Robinson's explanation. I can't give you or treat you the same way I can because your lands are notoriously barren and sterile. So he didn't offer them $10 times population. He didn't offer them $10 times 600 of their population. He instead, the best we can glean is that if the Crown believed that the $10 times existing population is the price to pay when you have no further commitments, you are in effect saying, and this is Hutchings and Stiglitz' approach, they say, if you believe that something is going to cost you $10, but you say because of the notoriously barren and sterile aspects of your land, I can only pay you $1.16 or $1.60, excuse me, $1.60.
There are two different arguments as I understand it. One, because it's barren and sterile, I will only pay you this. Or because we're broke. I can only pay you this.
Well, he said because we don't have the money and because, yeah, I think he used both.
Right.
He used both and said, number one, well, I'm not sure he told them he was hamstrung, but I think the evidence was quite clear that the provincial government was financially hamstrung. That's number one. And he did tell the Anishinaabe that their land was notoriously barren and sterile compared to the lands in the south. And he used that as an explanation as to why he couldn't pay what was being paid in the south.
You wouldn't encourage this approach on a real estate transaction. You've listed your house for 100, but because it's so ugly, I'll only offer you this, as opposed to, I only have this much money, so I'll offer you all that I have.
Yeah, I suppose not. But let's go back to, again, we're back in 1850. And so we have Robinson saying, I can't pay you the $10. What I can pay you is an amount of 500 pounds that turns out to be $1.60 of, like, you still have to go, you do the math of the population. If you want to compare apples to apples, $10 to the population at the time, whatever it is, to $10, 500 pounds, $2,000 to 1,240 people. You get not $10, you get $1.60. So that's a way of saying that instead of paying $10 per person fixed on the date of treaty of 1,240 people, right? Because that would have taken $12,400. I'm paying an annuity of $2,000, which is $1.66 per person for 1,240 people. And so that's how the ratio of 84-16 comes about. That the two parties entered the treaty as though it was a joint venture where they were each contributing to the joint venture.
Well, I understand the relationship between 84-16 and $10 and $1.60.
Yes.
It's in between there that I get lost.
When you say in between
those two propositions, those two assertions, $10, the ratio between $10 and $1.60 happens to be 84-16.
Right.
I can understand that. Why a treaty, or why an offer of $1.60 a person, if it can be expressed that way, the equivalent of $1.60 a person, yes, and a promise and a promise that doesn't exist in the $10 treaties, why that puts one party in the position that they should now get the benefit of the $10 or the equivalent of $10 a person. They didn't get $10 a person, and when they couldn't get, when the Anishinaabe in bargaining or in negotiating at the Treaty Council could not achieve $10, if they would have been happy with that, we're not sure, but the Crown thought that was a fair deal. When they couldn't do that, they gave an additional term. They made an additional term in the treaty. So why at compensation time, years later, do you go back to should get something that is measured against the $10?
Okay. It has to do with, I'm going to say, the human condition, common sense, and bargaining theory. Let me start with common sense, and let's go back to 1850. Crown comes up to say to the Anishinaabe, can't pay you $10 per person. Can only pay you $1.60 per person. So far, you understand that ratio. That's can't pay you 100%, can only pay you 16%. Now, the Anishinaabe might say, if they accepted that, well, what do you mean you can only pay us 16% of the buyout? If, now, the Anishinaabe didn't think that there was a buyout, but we're looking at it from the Crown's perspective. If the Anishinaabe were to say, what do you mean you can only pay 16%? Fine, we'll sell you 16% of the land. We'll keep the other 84%. You can, if you want to buy at the fair market value or at the going rate, we'll sell you 16% and we'll keep the other 84%. So that's kind of like a common sense thing to do. The bargaining theory asks, what would, with that kind of ratio, what would the parties expect if there was competition for the Anishinaabes to buy the Anishinaabes territory? And Stiglitz actually comments on this, and he says if there was equal bargaining, it would, by bargaining theory, turn out to be 84%. I believe that's at, oh gosh, I don't know if I didn't note the citation down. We'll get that for you. He then goes on to say, this was during cross-examination towards the very end. It's actually at the very end of his cross-examination. He said that if there was equal bargaining power, it would turn out to be 84%. But if there was only one purchaser who was motivated only by self-interest, then the result would be 58% to the Anishinaabe based on bargaining theory. And I've just found it. Transcript pages 704 to 706, line 16 and following. So Stiglitz explained that it was bargaining theory that drove the 84%, but he conceded that if in that economic bargaining theory, one were to assume, and this was, I believe, whoever was cross-examining him elicited the response that if there was only one self-interested person to sell to, and that self-interested person was only concerned with their own self-interest, that the bargain that would be driven would be 58% to the Anishinaabe and the lesser balance to the Crown. So that's the explanation on bargaining theory as to why 84-16 makes sense. The court may also recall, sorry, the court might have more questions on this right now.
I don't, it doesn't help me, but I don't have any more questions.
All right, well, let me.
I don't get this part about.
Yeah, go ahead.
The Anishinaabe could have said, when the offer came in, 500 pounds, $1.60, equivalent to $1.60 per cap.
Yeah.
The Anishinaabe could have said, okay, we'll only give you 16% of the land.
Yes.
They could have said that.
It could have.
Or they could have said, we want something else. We want future production from the land. We want a share of that.
Right. And so then you would then ask, well, how much of a share? And that's where Professor Stiglitz's opinion comes in, which is, well, how much of the share, if instead of giving you 16% of the land and us keeping 84% of the land, what are you bringing to the table? Well, I, says the Crown, I'm going to contribute 16% of the cost of the land. You contribute 84% of the value of the land to the venture. And that's the split. They're splitting the profits in proportion to their risk. That's Stiglitz's answer. He's saying 100%, and we know based on the 1684 split, that what's happening is that the Crown is putting up 16% of the risk, and the Anishinaabe are putting in 84% of the value. So they're sharing, what goes in comes out.
So it's based on this, 84-16 is based on this premise that they kept back 84 in their minds. They kept back 84%. They didn't get value. They didn't get paid for 84%. So they bring that into what you call a joint venture.
Yeah, except it wouldn't be correct to say they were thinking that. It's more correct to say that an economist trying to define and understand what is a fair and just sharing makes of their actions. It is not, and I do not try and argue that the Anishinaabe had in mind 84%. What they had in mind was a result. But if you're trying to define it in economic terms, which is all the economists could do, remember the evidence was that the Anishinaabe didn't define it as a percentage. The Anishinaabe defined it as, I'm going too fast for the reporter, I apologize. The Anishinaabe defined it as a kinship sharing, a relationship, and the economists were asked to bring some economics to the table. Now, if we ignore the evidence of the economics, and if we ignore bargaining theory, what we're left with is the evidence in this case that the Anishinaabe wanted to be treated at least as good as their fellow Canadians, which brings us to the only number being 153 to 193 billion. So the Anishinaabe perspective alone takes us to the higher amount because it's focused on a result, not on a percentage. So the Anishinaabe perspective alone would take us, I guess, I've already conceded we're stuck with the maximum of 126 billion. But that's where the Anishinaabe perspective would take us. But the economist's perspective, in looking at the actions of the people on the ground in 1850 and trying to put a rational explanation to their conduct in economic terms, Professor Stiglitz says, if you apply bargaining theory to what they did, this is the result you get. And he did admit of two different outcomes. One was 84% to the Anishinaabe, and the other was 58% to the Anishinaabe. And the 58% is predicated on the Crown being a self-interested person to whom only the Anishinaabe could only sell to one person. So there's only one market. And in that case, bargaining theory says, if you have a Crown or that one person who you can sell to, who is only going to be motivated by self-interest, the Anishinaabe share would be 58%. Now, I do not advocate for the 58% because part of the duty of the honor of the Crown is not just in treaty implementation. The honor of the Crown applies to the making of treaties as well. I don't need to take the court to the law on that, do I? So we say that as a matter of law, the Crown would have been compelled to enter the negotiations on the basis that it would treat the negotiations fairly, which would bring it back to the 84-16 approach. Now, I think I've answered your question as best I can. Whether
it did help.
Okay.
Last time through.
In cross-examination of Professor Bodway at 7643, Professor Bodway admitted that the risk or cost of the 2,000 pounds per year is really only cash flowed by the Crown, which administrative costs are borne ultimately by the Anishinaabe, or the risk of the expenses are borne by the Anishinaabe, who effectively bear 100% of the cost of the expenses before there is any share at all. And it's interesting, Professor Bodway said, if that's, and I put that as a hypothetical to him, he said, well, if that's the way the contract is written, and you can carry forward the losses, which is exactly Ontario and Canada, and even the plaintiff's position on this, that you can carry forward the losses. If that's the way the contract is written and you can carry forward the losses, I agree. I then suggested to him at page 7643 that, look, don't call it a contract, let's call it a bargain. And he volunteered, no, let's call it a joint venture. So Professor Bodway properly understood that this was a joint venture. Oh, I can't read my writing again. It's page 7613. I said 7643. Thank you, Ms. Lewis. Just as this is a bit of a digression, just for a moment. I've got a note here that at page 7514, Professor Bodway said that an element of sharing must take into account the relative wealth and disparity. But you'll note that Ontario and Canada's approach takes no cognizance of relative wealth about how the pie is shared. So I just make that observation.
That was in response or?
That was in response to nothing, but it was just in my notes in the wrong place. But it was in response to a question that the court had asked about relative wealth and needs sharing. So again, that's at page 7514 and Professor Bodway. One of the criticisms that was levied against a percentage sharing is that, well, no one was actually thinking in terms of percentages. Now, I think that's fair, but the economics have to come up with some division, and they're not coming, some method of sharing, and it's invariably because of the definition of math going to be a percentage. So I don't think that's a fair criticism. And we are not saying that in the future, in any engagement process, it will necessarily stay at 84-16. We do say that absent the Crown demonstrating good faith and honor of the Crown and convincing the court that 84-16 is wrong, that is in a go forward until there's agreement or court order or otherwise, it's as good a place as any to start, especially considering, remember the pie, where the resources are just a tiny sliver now. It's not so unfair. The economic model has to identify some dollar amount. So that is time for a break.
Thank you. We'll take that break.
Order, all right.
This court is sit down for 15 minutes.
Thank you.
This court is resumed. Please be seated.
Before the break, and at timestamp 22:34:34, at 2:34:34, I misspoke. I had intended to say that it is not fair for the defendants to say we didn't honor our obligations for 173 years. And now, court, you must go easy on us because it's so much money. I think I used some other party's name, not the defendant's name.
Thank you.
Turning then,
You might have said it's not fair for me to say.
uh, I think I had put in someone else, one of the plaintiff parties instead of the defendants. So it's
Okay,
all right. So I wanted to turn to the source of the treaty obligation, breach and infringement and justification. And now we're getting into what I consider to be an interesting area of the law in terms of how to conceptualize what is going on here. And I think there seems to be a genuine difference of agreement between the Crowns and the plaintiffs about how to characterize what is going on here. And I want to start with a fundamental proposition that what we are doing here in this case is talking about obligations under treaty. The obligations under the Robinson Superior Treaty are found in the treaty document. They are not found in the Constitution. They are recognized and affirmed and embedded within our constitutional fabric, to be sure. But the source of the obligation is the treaty right itself. That is where you look to find the obligation. This is to be distinguished between Section 35 rights of consultation and public law rights of judicial review. And I don't know how clear it is in Ontario's arguments or not, but I understand their position to be, and perhaps even Canada as well, that they conceive of this treaty breach as a breach of the honor of the Crown, giving rise to consultation rights. And so you might remember the case of Mikisew from 2005. In the Mikisew case, in that case, the issue was, how do we deal with this alleged breach of treaty whereby there's a right in the First Nation to utilize lands for harvesting purposes, and the government wanted to build a road through a park. And it was alleged in the lower courts that there was a treaty breach. But by the time it got to the Supreme Court of Canada, it was about a conflict between the Crown having the right to take up land and the internal limit on the harvesting right. So an internal limit within the treaty itself. And the Supreme Court of Canada said, we are not concerned in this case, in the Mikisew Cree case, with treaty infringement. We are concerned with whether or not there has been adequate consultation and accommodation. So it's important that the court understands that from the plaintiff's position, this case is about a breach of treaty, not about a failure to consult and accommodate. The Crown, we say, has no discretion on whether to pay the augmentation if there is wealth to be shared and the conditions objectively exist to allow an augmentation. The treaty says the annuity shall be paid. There is not a question of discretion about it. This is not a case of simple consultation under Section 35, nor is it a case of judicial review of administrative government action. And I think Ontario and I can't say this of Canada, but Canada will stand up and explain their position. But I think for sure Ontario, maybe Canada, but I hope not Canada. But Ontario says your remedy is judicial review. We get to decide, we, Ontario, get to decide on form, level, and aim, and your recourse, if you have any, is to seek judicial review in administrative law. Canada, I think, says it's more of an honor of the Crown judicial review. But neither of them grapple with the plaintiff's position and the plaintiff's argument that this is a breach of treaty. Now, we said that the Crown doesn't decide on form, level, and aim, and the court is the final arbiter of what the net resource revenues are, not the Crown. The engagement process is a treaty obligation coupled with positive obligations of diligent and purposeful fulfillment. There is no discretion left with the Crown to engage in a process, to refuse to engage in a process, nor is there discretion to pay or to refuse to pay if objectively the territory produces an amount that enables them to do so. And in all the case law, in all the years, there's not an awful lot that's going to be of help to the court. But there is one case decided by Justice Burke of the British Columbia Supreme Court in the case called Yahey, Y-A-H-E-Y. I think it's the Blueberry River case, which has a good discussion of the issues, which can serve for today's purposes as a foil, if you will, to address the issues that I think the court needs to consider. We talk about this at paragraph 528 of our argument, but I want to turn and really just discuss the Yahey case and the principles that are laid down there. So it's tab 16, starting at page 91 of the compendium. And I'll wait for you to, you're there?
Got it, thank you.
So the Yahey case, and I've yellow highlighted most of the parts that I'm going to go to. And the case was about, now while it was a harvesting case as well, the judge in that case ended up deciding there was a treaty breach, a prima facie breach of treaty. He decided that there was an infringement, and he decided that there was no justification for the infringement.
By chance, is it she?
It probably is, and I also said plaintiff instead of defendant earlier. Yeah,
Some mistakes are worse than others.
indeed. Justice Burke goes on, and this is just the head note. There was there was the diminished ability of the First Nation members to exercise their rights to hunt, constituted infringement of their treaty rights. The province had not justified infringement. Province had not shown that it had appropriate enforceable way of taking into account First Nations treaty rights. And the action ended up being allowed. Now, over on page 93, last bullet before the conclusions, in this case, Blueberry alleges it's not a single impact, but many impacts. And then it's in the yellow, has resulted in significant adverse impacts on the meaningful exercise of the treaty rights. And that amounts to a breach of treaty. Then over on the next page, paragraph 94, on page 94 of the compendium, under the heading infringement of treaty rights. In Sparrow, the Supreme Court of Canada set out the test for establishing an infringement of Aboriginal rights. In Badger, the court confirmed that the test also applies to an infringement of treaty rights. Then at paragraph F at the bottom, going over to the next page, under justification of infringement, the court makes the observation at paragraph 97, once an infringement has been established, the onus shifts to the Crown to demonstrate that the infringement is justified. Paragraph 98, Sparrow lays out a two-step analysis with respect to justification. This is applicable to infringements of treaty rights, citing Badger and Mikisew. The court then spent some time at paragraphs 445 and following, trying to analyze what is the test for the Supreme Court of Canada and in lower courts of, does an infringement of a harvesting right, is it only an infringement if there is no meaningful right left? Right? And I believe that the Supreme Court of Canada has approached the matter unclearly in some respects when it comes to harvesting rights, but they actually set down the law correctly in a case called Morris. Now Morris, and you'll find, if you turn to page 485, sorry, not page 45, page 101, paragraph 485 of the Yahi decision, you'll find the excerpt to Morris. Now Morris was a hunting case, and in Morris, the Supreme Court of Canada considered the meaning of the concept of prima facie infringement in the context of Section 88 of the Indian Act. The majority of the Supreme Court of Canada reasoned at paragraph 53 that a prima facie infringement requires a meaningful diminution of a treaty right, which includes anything but an insignificant interference with that right. Now, Morris also ruled spoke a fair bit about interjurisdictional immunity. The law in respect of Morris and interjurisdictional immunity has been overtaken by the Supreme Court of Canada. So the interjurisdictional immunity part is not good law anymore. But the part of Morris dealing with what it takes for prima facie infringement, that is still, as far as I know, good law. So how do you reconcile that with the case law that seems to suggest?
Is that comment that you just made, is that also found in this decision of Justice Burke?
Okay, let's jump to that. Justice Burke at paragraph 529 comes to the following conclusion after looking at all of the case law.
So,
Well, including the case law, which suggests that, the case law that suggests that infringement requires no rights remaining, right? And at paragraph 499 and following, Justice Burke talks about the Mikisew case and about the no rights remaining not being the test, and distinguishes and explains why that's the case, and comes to the conclusion at paragraph 529, while different language is used to describe the middle ground, in my view, all of the phrases above are trying to get at the idea of rights being diminished in a meaningful or significant way. I find it appropriate to consider whether there has been an infringement of Blueberry's treaty rights, but by considering if there has been a significant or meaningful diminution of the rights. I will say more on this below. So that's ultimately the test that Justice Burke arrives at. It really is a recitation of the Morris criteria from the Supreme Court of Canada. And the reason why I've included Yahi is because it's such a good summary of all the different cases and puts squarely for this court's consideration the legal issues that are going to be engaged as you write your decision. So we say that Morris is correct and Justice Burke is correct at paragraph 529, and that the nature of treaty breach involved in this case is far different than that engaged in Mikisew about harvesting rights, and also that in Grassy Narrows, which is also involved harvesting rights. Page 108 of the compendium, paragraph 1134, under the heading heading 8, has the province diligently implemented the treaty? So Justice Burke is firmly grasping the direction and rulings of diligent implementation of the treaty. And there were really two aspects of this particular case, the Yahi case. It was ultimately a breach of fiduciary duty case, but that doesn't distinguish it. It was breach of fiduciary duty within the treaty context. And so while there might be much to say about remedies by this court, on this court being the Yahi court, Justice Burke, in respect of fiduciary duty, the analysis of diligent implementation of the treaty still has importance for this court. And at 1136, the judge fixes on the honor of the crown as a foundational principle. And she says, as I discussed earlier, the honor of the crown is a foundational principle of Aboriginal law and governs the relationship between the crown and Indigenous people, referring to Mikisew. At 1137,
Just let me catch up for a moment.
yeah,
That last reference you read was 1134?
1136.
1136, thank you.
This is all yellow highlighted in the material. 1137, Justice Burke says, the principle of the honor of the crown was referred to in jurisprudence, dealing with the relationship between the crown and Indigenous people as far back as 1895. In Province of Canada versus the Dominion of Canada and the Province of Quebec, 1895, 25 SCR 434, a case concerning the Robinson-Huron Treaty and Robinson-Superior Treaty. There we go. Circle comes about. Justice Gwynne of the Supreme Court of Canada, writing in dissent, evoked the concept of the honor of the crown to explain the crown's approach to treaty making and interpretation. He noted, did the court get that? Treaty making? Yeah, I want to emphasize that. He noted that when entering into treaties with Indigenous peoples, dealing with the surrender of their lands, the terms to be performed by the crown have always been regarded as involving a trust graciously assumed by the crown, to the fulfillment of which the Indians, the faith and honor of the crown is pledged, and which trust has always been most faithfully fulfilled as a treaty obligation of the Crown. The next part of the decision I want to refer to is paragraph 1150 at page 110 of the compendium. This is a discussion on the MMF case from 2013, which was not a fiduciary duty case. Well, we had tried to plead fiduciary duty, but we were unsuccessful. What we were left with was the honor of the Crown. So at 1150, the court held that the Crown had undertaken discretionary control of the administration of the land grants, but that the Métis did not have a collective Aboriginal interest in the land since, as found by the trial judge, they used and held the land individually. So in that case, there could be no fiduciary duty. So at 1152, Justice Burke continues, Justice McLaughlin then turned to the arguments based on the honor of the Crown. At paragraphs 66 to 67, she noted the honor of the Crown arises from the Crown's assertion of sovereignty over an Aboriginal people and de facto control of lands and resources that were formerly in their control. B, goes back to the Royal Proclamation of 1763 and arises not from a paternalistic desire to protect Aboriginal people, but rather from recognition of their strength. C, has as its ultimate purpose the reconciliation of pre-existing Aboriginal societies with the assertion of Crown sovereignty, and D, characterizes the special relationship between the Crown and Aboriginal peoples. 1153, Chief Justice McLaughlin held that the honor of the Crown was engaged by an explicit obligation to an Aboriginal group that is enshrined in the Constitution, and that an analogy could be drawn between such a constitutional obligation and a treaty promise. Well, here we have a treaty promise. Over at paragraph 1154, at paragraph 75, the court found that when the issue is the implementation of a constitutional obligation to an Aboriginal people, the honor of the Crown is the honor of the Crown requires that the Crown, one, take a broad, purposive approach to the interpretation of the promise, and two, acts diligently to fulfill it. The court recognized that this duty had arisen largely in the treaty context, citing 79. And then the court says, because the Crown's honor is pledged to the fulfillment of its obligations, it must endeavor to ensure its obligations are fulfilled. Positive obligations. It is expected to carry out the work required with due diligence, as good governance requires decisions to be made in a timely way. And then, of course, not every mistake in implementation will bring dishonor. However, a persistent pattern of errors and indifference that substantially frustrates the purpose of the promise may betray the duty. Diligent efforts are required, even if circumstances may ultimately prevent the fulfillment of the obligation. And so that's pretty important in understanding breach here, a persistent pattern of errors or indifference. And I might say that the Supreme Court of Canada in MMF in 2013 was appalled by the unexplained 10-year delay in delivering to the Métis their rights that they had bargained for. Here we have a 173-year delay that is unexplained, unexplainable, unfair, and unjust. At the same page, down at paragraph 1160, I note that although the Supreme Court of Canada commented that the Crown was subject to both the honor of the Crown and its fiduciary duties, it did not expand. This is the court's talking about grassy narrows at this point. Specifically, what the Crown's fiduciary duty required it to do in relation to treaty rights, other than ensuring such rights were respected. The court noted that the province must consult and, if appropriate, accommodate the First Nation before taking up lands. The court also recognized that if the taking up amounts to an infringement, the sparrow badger analysis will determine if the infringement is justified. And here, I think, is the difference. In our case, we say this is not about taking up land. This is about a positive obligation to make a payment and to engage a process. This is about infringement, and the Spadger-Barrow analysis needs to be examined, we say, to determine if the infringement is justified. When the court in Yahi turned to the issue of has the province honorably and diligently implemented the treaty, we see at page 115 of the compendium and at paragraphs 1724 and 1725, the judge eventually gets to the answer of no. At 1725, the judge says, well, maybe I should read 1724. I think it's important. As noted by Blueberry were the plaintiffs in the case, the law requires the Crown to act with diligence and integrity to implement, so a positive obligation to implement, uphold, and protect the purpose and promise of Treaty 8. The honor of the Crown is engaged by constitutional obligations and treaty promises. Paragraph 1725, accordingly, the honor of the Crown requires the province to interpret the treaty in a purposive manner and to act diligently to endeavor to fulfill the promises the Crown made. Over at paragraph 731, but on page 116 of the compendium, well, actually, let's start at the beginning of 1731. One of the arguments that the court made out, that the province made out, they argued, well, wait a sec, this isn't a consultation case, so the complete record is not before the court. So the court cannot and should not assess the adequacy of consultation. And Justice Burke says, I agree that this case is not about consultation. It is, however, about whether the Crown has adequately and diligently implemented the treaty that it agreed to with Blueberry, along with other Indigenous peoples. That is the focus of the analysis. And I am suggesting to this court that the focus of this court's analysis is answering the question, has the Crown adequately and diligently implemented the Robinson Superior Treaty? And I'm inviting the court to say, no, they have not. Paragraph 172, the province has argued that if Blueberry was dissatisfied with the consultation that occurred in relation to any number of decisions, it ought to have applied for judicial review of the consultation process generally. I do not accept that judicial review was Blueberry's only option, or that it is barred from arguing in this action that the province's conduct to a variety of decisions missed the mark. So 1734, the judge says this claim is the appropriate place to consider the merits of whether the province has breached the treaty. And on the conclusions of honorable and diligent implementation, the court talks at 1781. The province has not to date shown that it has an appropriate way of taking into account Blueberry's treaty rights, assessing the cumulative impacts of development on the exercise of those rights, and developing a way to ensure that Blueberry can continue to exercise those rights in a manner consistent with their way of life, such that the promises made in Treaty 8 can be upheld, implemented, and respected. So there's a positive obligation on the Crown to figure out a way to make sure that the promise is honored within the Canadian Confederation. And so at 1787, the judge identifies the failures of the Crown. And then after concluding that there's been a failure to honor the treaty, turns to the law on justification. So the heading is on page 120 of the compendium. It's heading IX, has the province justified the infringement, and the court sets out the law. As paragraph 1810, as set out earlier, once a First Nation establishes that its treaty rights have been infringed, and we say that in this case before you, the plaintiffs have established that there has been breach of treaty. There has been breach of the obligation to engage in a process, and there has been a breach of an obligation to pay a share of the productions from the treaty territory. So once there's the First Nation established its treaty rights have been infringed, the onus shifts to the Crown to justify the infringements on the basis of the Sparrow Badger test, or makes reference to Grassigneros and Sparrow. The justificatory standard has been recognized as placing a heavy burden on the Crown. 1811. In Badger, at paragraph 82, Justice Corey reasoned, it is equally, if not more important, to justify infringements of treaty rights as it is to justify infringements of Aboriginal rights. This was said to be because the rights granted to indigenous peoples by treaties usually form an integral part of the consideration for the surrender of their lands. And on that little bit of evidence, this court will recall that it was the augmentation clause that was the remaining piece of the puzzle that allowed the treaty to be entered into. It was the integral part of this treaty that allowed this treaty to happen. At paragraph 1815, Justice Burke notes something that this court is going to have to grapple with as well, I think. Subsequent Supreme Court of Canada decisions looking primarily at infringements of Aboriginal rights, as in Gladstone, or Aboriginal title, as in Delgamuukw or Chilcotin, as opposed to infringements of treaty rights, have noticed that the framework for justifying infringements to Section 35 rights generally involve considering the following. First, whether the government has consulted and, if necessary, accommodated the Indigenous group. Second, whether the government has established a compelling and substantial government objective. And third, whether the government's action is consistent with its fiduciary duty and the honor of the Crown. This last step may involve considering the nature of the interest to which the Crown's fiduciary, perhaps fiduciary duty attaches, is what was meant here. There's a word missing, I think. Whether the action is necessary to achieve the government's objective, whether the government's action was minimally impairing of the right, and whether the benefits expected to flow from the objective are not outweighed by the effects on the indigenous interests. 1816, what constitutes a compelling and a substantial objective is to be considered from the indigenous perspective as well as from the perspective of the broader public, Chilcotin. Such objectives are directed at recognition of the prior occupation of North America by indigenous peoples and reconciliation of this prior occupation with the assertion of Crown sovereignty. Now, at paragraph 122, Justice Burke observed, page 122, paragraph 1822, Justice Burke observes, the province's primary response to Blueberry's claim is to deny that Blueberry's treaty rights have been infringed and to deny that the treaty has been breached. Well, we have the same sort of argument here with Ontario saying, we have not committed any breach at all. And what Justice Burke says at 1828 is instructive. In its latter written and oral arguments in this case, the province has taken the position that it could not justify any infringements of Blueberry's treaty rights until first, the scope of the rights are known, and second, the specific infringements were identified. Now, we haven't heard yet from Ontario and Canada on this, but I expect them to say the exact same thing. That, well, Justice Hennessy, we're only now learning that what our treaty rights are. How could we possibly be held to have infringed anything? There needs to be a stage 4. I'm encouraging the court not to go to stage 4. I'm taking the position that there is enough on the evidence and enough notice to Ontario and Canada to have mounted their defense, which in fact they did, to say that there was no treaty breach at all. And this is exactly the problem that was facing Justice Burke. And at paragraph 1830, Justice Burke says, the province emphasized that specificity regarding the nature of the infringement is required in order for the Crown to seek to justify its actions. 1831, in its oral reply, what did counsel for Blueberry emphasize? Much of the evidence led by the province in this case was of the type that would be expected with respect to justification. The Blueberry argued that if the court found an infringement, there would be a substantial prejudice to Blueberry to find that it was anything other than an unjustified infringement. And the court concludes in 1832 to 1834. I will deal first with the province's position that it could not advance a justification defense before the scope of rights were known. Answer, 1833, Treaty 8 rights are established and existing rights, not claimed or asserted rights. The starting point is that the Indigenous people are entitled to what they have been granted in the treaty. Let's leave the granted or negotiated or agreed to. There is substantial amount of jurisprudence from this court and appellate courts as to the promises included therein and the scope of their rights. Those are Treaty 8 rights. 1834, the province must be taken to know the promises the Crown made to Indigenous people and which it is bound to uphold today, ensuring those rights are respected and upheld, or in the alternative, ensuring that infringements of those rights are justified does not always need to await judicial determination of the specificity or scope of the rights. While some clarification may be needed or assistance, to proceed on the basis that the treaty right is not known until the court determines what the right is is unwieldy and ignores the reality of the written document, the known oral promises, the plentiful jurisprudence, and in this case, the specifics set out by the plaintiffs. And I would add, in this case, the judgment in phase one that identified that there are treaty rights and what those treaty rights are. At paragraph 1841, Justice Burke says, in the court's view, no further specifics regarding the nature of the rights on which Blueberry was relying was required in order for the province to bring forth evidence and prepare an argument seeking to justify any potential infringement. And 1842, that says, the court says, I now consider whether the province needs to await determination from this court on the nature of the infringement before it can seek to justify the regulatory regime and or specific decisions it makes. The court says no on that score. At top of page 127, paragraph 1826, court rejects province's argument, says much of the province's arguments with respect to consultation in the honor of the Crown are relevant to the justification analysis. My earlier conclusions apply here with equal force. The province has not demonstrated it is acting in a manner that upholds the honor of the Crown. Now, they also mention or meets the fiduciary duties, but we can leave that part off. It's the honor of the Crown that we're concerned about. In relation to Blueberry's treaty rights, the same can be said about this case. The court then makes a couple comments that I think are important for this court to keep in mind at paragraphs 1868. The courts are the guardians of the Constitution, and the duty of the judiciary is to ensure that the constitutional law prevails, citing the Manitoba language rights case and the MMF case from 2013. 1869, the Supreme Court of Canada confirmed in Sparrow that Section 35 is protective and remedial. In accordance with the purposive approach to construing Section 35, remedies relating to Aboriginal and treaty rights should be sensitive to and advance the distinct purposes of Aboriginal rights, including the importance of treaty making as an honorable form of reconciliation, citing Kent Roach. 1875, in this case, as we will see below, I am the view that a combination of broad declarations regarding the infringement of Blueberry's treaty rights and breach of the treaty, along with more specific declarations about what is required to remove the breaches of the treaty and to uphold Blueberry's treaty rights, is appropriate in order to guide the parties. So we ask this court in this case to also not only declare that there's been an infringement, not only make an award for past amounts, not only to declare that there has been that the infringements have not been justified, but to provide meaningful guidance both generally and with specific guidance to help the party, help the Crown ensure that in the future it will not fall into the same problems of breaching the treaty. Declarations that will ensure that the Anishinaabe do not fall in the cracks of the constitutional division of powers. Now, at paragraph 1883, Justice Burke makes the comment, The province was on notice to argue justification and did not do so. In this case, in the Court of Appeal, Justice Horrigan rejected fiduciary duty because in his view, it would not allow the Crowns the ability to justify their conduct. He said, we can't have a fiduciary duty here because we need to give space for the Crowns to justify their breach or justify their conduct. I don't think he used the word breach, justify their conduct. They were on notice, my friends. While it is noted in the trial brief that it would be unfair to hold the province while it noted in its trial brief that it would be unfair to hold that the province has failed to justify any infringement without providing the parties the opportunity to negotiate or for the province to adduce further evidence, I disagree. This trial was not bifurcated, and timelines and delay have been a pervasive problem during the regulatory process, as evidenced by the province's responses over the years to Blueberry's concern. The province has known for a significant period of time that its processes are at issue. Accordingly, those infringements have not been justified. Now, in this case, the case was trifurcated, but the point that Justice Burke was making was that at the final disposition of the case, the issue of justification was not hived off. And justification and the defenses of the Crown were not hived off for part 4. Some of the defenses were hived off in part 2, limitations and lashes and Crown immunity. That was shaved off and dealt with. But there was no agreement and no expectation from the plaintiff's point of view that after we receive a determination that there's been an infringement of the treaties here, that we are going to now have phase 4, where Canada and Ontario then get to say, give us space to negotiate, give us space to work with the plaintiffs, give us room to come up with our own solution, and give us then chance to justify our infringement. That time, respectfully, has passed. And the time for them to have justified their infringement was as part of this case. And to be fair to the Crowns, they did muster arguments to explain why their conduct was reasonable and appropriate and not in breach. So they've marshaled the kind of evidence that one would marshal for trying to establish that there's been no infringement. One of the things I would ask the court to note is that, and I believe this is in my argument, I'm not sure where, but invoking public policy in justification of Crown's conduct can never be justification. So says the Supreme Court of Canada. And if I have to find a site for that, if that's a principle that's not known, we'll get it tomorrow. But I believe that might be from Grassy Narrows, or at least it was repeated in Grassy Narrows, I suspect. And the reason for that is you just can't say public policy, we had to do it, we had other obligations to other people. That's not good enough. You have to be specific, and you have to identify why in each instance you had to make the decision that you did. So for example, in this case, when it came to a decision to give subsidies to railways, for example, the Crown would have to establish, we had to, let me explain, here's the explanation from a historian, or here's the historical data explaining why, Justice Hennessy, the compelling objective had to include paying an amount to the railway, and why that compelling public objective is sufficient to allow you to forgive our breach of not paying the amount that's due. It doesn't,
Well, are you suggesting that explanation for any policy decisions related to expenses is relevant to a justification for the claims before this court? Not, no process and not paying the treaty promise?
well, if there is, let's say there was a policy, maybe I can try and answer it this way because I'm not sure I understand the question. But suppose the government wanted to defend the fact that it hadn't engaged in a policy because
Hadn't engaged in a,
in a process, it hadn't engaged in a process with the Anishinaabe over the years because it was concerned that Germany was going to invade. And it couldn't do it because if it,
justification is with respect to not engaging in the process.
there,
Not with respect, or I'm wondering if you're saying it could be with respect to how a single category of expenses.
well, I think it could be, because if we're saying that it's a justification, that it's a breach not to include in a certain amount of expenses, and Mr. Hutchings has given evidence about,
You don't say that's the breach.
no, I don't say that's the breach, but I'm saying if the Crown wanted to justify the breach, to say there's a breach here of not paying, and if they say we couldn't pay them because it was, they can't just say we couldn't pay them because of public policy. They have to do more. They have to come up with a reason for the breach. They have to justify the breach, and I don't understand, I can't imagine what evidence they would have brought to justify the breach, because justification requires turning your mind to paying the Anishinaabe for the breach, which the promise here is payment. So I don't know how they could possibly justify a breach. But whatever justification they may have thought about, it's not enough to invoke, oh, public policy, or this is the way government operates. They would need to come up with some sort of specific explanation as to why they couldn't honor the treaty. Now, I think anything they would say, my response would likely be, yeah, but you could have just paid. You know, if you couldn't, for example, they might, if their argument was, yeah, but what you're asking us to do is to change our policy and to charge industry more. We'd say, no, we're not. We're not asking you to change your policy. We're just asking you to pay us the fair market value of that you're deciding to give away. So justification would say, well, did you pay them? The answer is no. So I don't know what possible justification the Crowns could mount. I do know they didn't bring it in this case, and I do know the time to bring it was in this case, and I have no desire to leave any suggestion to the court that it would be appropriate for the Crowns to be given the space to let us negotiate, let us work it out, let us discuss. And then if we can't do that, then we'll come back to you and we'll argue about justification. That should not be on. There is much to talk about for the future, and with the court's guidance on the future that we hope the court will grant, we hope to have lots to talk about for the future implementation, but that requires parameters from the court. Now, that concludes my discussion about Yahe. The principle that you can't invoke just public policy and justification of Crown conduct comes from our paragraph 192 in our reply argument, footnote 77, reference to the venerable case of Sparrow.
Thank you.
Now I see that it's 4:30. I still have a little bit of time to go. I'm judging, I probably have about another hour. Yeah, I see some faces saying, do it tomorrow, Harley, and I'm quite happy to do that. I still don't think we're stressed for time. I had hoped to finish today. I'm about an hour off. What is the court's wish?
I agree with the results of the survey. All right, let's break for the day, and we will, that suits the Crowns. You're going next, Canada. Oh, group of 7, you're not going next.
I think I will be up next sometime in the
Right.
morning, followed by the class. We expect to be about a day.
Okay, very good. Thank you. So that was the other reason he didn't want you to go till 4:30, to 5:30. All right, so we'll break now, and we will convene at 10 tomorrow. Thank you. Yes, I'm gonna send them.
Order arrived.
This court is adjourned until September 14th, 2023 at 10 a.m.